Senate Judiciary Committee will resume. I would like to make a statement in terms of some research that was undertaken during the break. Judge Jackson, earlier Senator Cornyn said that you had called former President George W. Bush and Secretary of Defense Donald Rumsfeld a, quote, war criminal, unquote. I noticed a little surprise in your reaction, and I was surprised by the allegation. During your service as a public defender, you filed several habeas petitions against the United States, naming former President Bush and former Secretary Rumsfeld in their official capacities. You were advocating on behalf of individuals who argued they were civilians wrongly classified as enemy combatants of the United States, and your filing was part of your professional responsibility to zealously advocate for your clients. In those petitions, the individuals raised more than a dozen claims for relief, one of which was an allegation that the government had sanctioned torture against the individuals, which constituted war crimes under the Alien Tort Statute. The Alien Tort Statute allows courts to hear cases for alleged violations of the law of nations or the treaties of the United States. Apparently, this is what Senator Cornyn was referencing. So to be clear, there was no time where you called President Bush or Secretary Rumsfeld a, quote, war criminal, close quote. Did you want
correct,
to respond?
Senator. No,
Okay.
Thank you. That was correct.
Thank you very much. We now recognize Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Jackson, for being here. I want to talk today about some things you heard about yesterday. There was a lot of talk from members of this committee about judicial philosophy. I want to talk a little bit about what that means and why it's important. We'll start with what it means, at least to me. One of the things that you heard from a lot of members of the committee, whether they couched it in terms of judicial philosophy or not, relates to the idea that justice should be blind, that justice properly administered within our system is blind, and that therefore individual justices and judges serving in Article III courts should be blind in the sense that they are able to see and understand and interpret the law, understand what the law is, while understanding that the idea of what the law should be is left to other branches of government, not to the judiciary. In this respect, we recognize that blind justice and blind justices, those who are blind to the things they're supposed to be blind to, are those willing to recognize that if there is a policy flaw in the law, and if there's a policy change that needs to be made, it's not the role of the court to change it. That belongs to two different branches of government, primarily to Congress. This, of course, requires judicial restraint. It requires judicial humility. And it gets back to what I was describing yesterday when I referred to Justice Barrett drawing on the analogy from the Odyssey of Odysseus binding himself to the mast of the ship. Most of us refer to this judicial philosophy as textualism. Textualism is neither liberal nor conservative. It's neither Republican nor Democratic. It's just the approach that says what the law says matters, and the job of the jurist is to look at the text and figure out what the text means, to ascertain the original public meaning of the text in question. While I doubt there are any members of this committee who would disagree with the idea that justice should be blind in this respect and that policy changes need to be made by the political branches of government, primarily by the legislative branch and not by the courts, you did hear some statements that I think are at least a little bit at odds with that concept of justice. One of my colleagues mentioned that you should interpret the Constitution in a way that works for the people of today. Fair enough. We certainly don't want to interpret the Constitution in a way that doesn't work. But again, that's not the objective. The objective is not to ascertain good policy. The objective is to ascertain what the law requires. You were urged to consider the effects of the court's actions on people's lives. There again, insofar as this relates to policy, it's not really the job of the courts. You were admonished that you must, quote, be able to see the real people at the other end of the court's rulings like Americans who are one Supreme Court decision away from losing their health insurance, or one court decision away from the ability to make their own health care choices. And the list goes on and on. Now, that type of judicial philosophy would have you step into the role of policymaker and decide what the law should be rather than what the law is. You also heard quoted a couple of times yesterday, quoted or paraphrased or otherwise referenced, Federalist 78, in which Alexander Hamilton refers to the difference between between will and judgment. Will, as expressed by Hamilton, refers to what the law should be. Judgment pertains to what the law is. The judicial branch has the latter power, but not the former. The legislative branch has the former, but not the latter. Judge Jackson, I'd love to get your thoughts on this discussion about what it means, what blind justice is, why that's important. Let's start with this formulation of it, though. Does the law determine the outcome of a case, or does the outcome of the case determine the law?
Thank you, Senator. The law determines the outcome of case.
And so anytime you're looking at a case and you're looking at the outcomes for ordinary Americans, for day-to-day Americans, if you're looking beyond the scope of deciding that case, and if you're looking even within that case beyond what the law says, you would be stepping into a province of a different branch. Is that right?
I believe so. The law and the facts of the case determine the outcome of cases.
I think that's an accurate statement. It's important to emphasize this. This is also something that Hamilton describes in Federalist 78, where he goes on to say, anytime you start to see the courts start to exercise will instead of judgment, the result is supplanting the will of the people as expressed through their elected representatives through the courts. And that tends to undermine the whole system. You see, there's a reason, of course, why we give life tenure to Article III judges and justices. And that is because we want to make sure that they have the power, the authority, the discretion, and the confidence to issue a decision that they might not be comfortable with. In fact, a judge who always agrees with and is always comfortable with his or her own opinions is, as Justice Scalia used to say, not a very good judge. So we wanted them, you, all, to have confidence in being able to make the right decision, even knowing that you and the public at large might be uncomfortable with the result it produces. Congress makes laws that you won't always agree with. Congress is accountable to the people at regular intervals. You can fire every member of the House of Representatives every 2 years. You can fire 1/3 of us in the Senate every 2 years. We insulate judges and Supreme Court justices from that same accountability precisely for this reason. It's because political accountability is so important. This is borne out in the judicial oath, one of the oaths that you'll take if confirmed to this position as an associate justice, in which you'll swear or affirm that you'll administer justice without respect to persons, and that you'll do it faithfully and impartially. I read this to mean that you do it without consideration of external circumstances, external considerations, policy considerations, or otherwise. Now, this relates to some interaction that you and I had when you came before this committee for your confirmation to the U.S. Court of Appeals for the D.C. Circuit, where you now sit. In connection with that hearing, I submitted some questions to the record in which I asked you whether, to what extent, the Constitution protects rights that are not enumerated in the Constitution itself, and if so, to specify what those rights were. You responded by citing a number of cases, including Griswold versus Connecticut, Roe versus Wade, Loving versus Virginia, and a handful of others. You also suggested that the Ninth Amendment was a source for such rights, unenumerated rights. The Ninth Amendment, of course, states, quote, that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Judge Jackson, what specific rights has the Supreme Court identified as flowing from the Ninth Amendment? And by that I mean specifically from the Ninth Amendment, rather than in sort of an also-ran list of other features of the Constitution that might back up a particular ruling. What rights has the Constitution identified as flowing specifically from the Ninth Amendment?
Thank you, Senator. The Supreme Court, as I understand it, has not identified any particular rights flowing directly from the Ninth Amendment, although, as you said, the text of the amendment suggests that there are some rights that are not enumerated.
Right, right. Its very existence and its very language suggests that, which opens up other questions as to how those are to be resolved. It's led to considerable debate among scholars and jurists alike as to whether, to what extent, in what way this is enforceable. Those rights are enforceable by the courts. But how would we go about deciding that? How would jurists go about deciding this question appropriately? In other words, would it be more appropriate to say we will ascertain the existence of rights protected by the Ninth Amendment based on contemporaneous understanding at the time of the ratification of the Ninth Amendment? Or would it be more open-ended to protect rights that we think are important today?
Thank you, Senator. The Supreme Court now very clearly has determined that in order to interpret provisions of the Constitution, we look to the time of the founding. And we ascertain, based on what the original public meaning of the words of the Constitution were at the time. Sometimes that yields a particular answer. Other times you may have to look to practices historically from that time. But that would be the way in which you would go about interpreting the Ninth Amendment.
Could it also be that it leaves this to be decided at the discretion of the Supreme Court itself? In other words, not based on any historical precedent, but based on what the Supreme Court justices themselves deem appropriate at the moment?
I don't think so.
Why is that?
Because the way in which the Supreme Court interprets the Constitution is with reference to the meaning of the text at the time. That it is one of the constraints, as I mentioned, in terms of my own way of handling, interpreting the law. One of the constraints is that you're bound by the text and what it meant to those who drafted it.
At the time, gotcha, yeah. Now, on February 1st of this year, President Biden said that he was looking for a Supreme Court nominee. This was, as I recall, right after Justice Breyer announced that he would be stepping down and before he had announced whom he might nominate, that he was looking for a nominee, quote, with, quote, a judicial philosophy that's more one that suggests that there are unenumerated rights to the Constitution and all new members mean something, including the Ninth Amendment. So do you share the judicial philosophy that President Biden described in that statement?
Senator, I haven't reviewed that statement, but I have not discussed anything about unenumerated rights with the President. Yes.
Did President Biden ask you either about your judicial philosophy more broadly, separate and apart from the Ninth Amendment, or ask you about your approach to the Ninth Amendment?
He did not.
In a primary election debate that he had as a presidential candidate in Nevada in 2007, Joe Biden stated, quote, "I would not appoint anyone who did not understand that Section 5 of the 14th Amendment and the Liberty Clause of the 14th Amendment provided a right to privacy. That's the question I'd ask them." If that is answered correctly, that is the case, then it answers the question, which means they would support Roe versus Wade. I assume his reference to the Liberty Clause, I assume he's referring to the Due Process Clause of the 14th Amendment. In context, that appears to be what he's saying. Did President Biden ask you whether you agreed with his analysis of the 14th Amendment as it relates to the right to privacy?
He did not.
Tell me this. When we look at any provision of the Constitution, one of the many reasons it's helpful to look at the original understanding, in addition to the fundamental reason that you described, it can help us understand what motivated it, and it can help us understand the actions of those who voted within Congress to propose text to be amended to the Constitution and those who voted to ratify it. We've got a number of amendments, including the amendment that he referred to in that last quote I read, that had an understanding, at least an understanding that included certain thou shalt nots for government. The Equal Protection Clause, I think, is a provision of the 14th Amendment that people understood. Among anything else it might do, restricts government's ability to treat people differently on the basis of race. Consistent with the Equal Protection Clause of the 14th Amendment, when is it permissible for government to treat a person differently on the basis of race?
Thank you, Senator. The Supreme Court has interpreted the Equal Protection Clause, as you say, to generally prohibit classifications on the basis of race. And it says that those classifications are to be rigorously scrutinized. They are strict scrutiny, which is a standard that applies, that looks at the purposes of the government and the means by which the government seeks to achieve any end related to such classification. The government would have to have a compelling interest in making that classification, and the means that it selects would have to be narrowly tailored to achieve that interest.
And so those compelling interests can't be for light or transient reasons. They can't just be something like we feel like it, in other words.
Correct.
And the reason for this is because, well, number one, it's bad for anyone to treat another person differently on the basis of race. It's especially bad when government does it, because there's not exactly equal bargaining power when you're dealing with the relationship an individual has with government. By definition, it's a particularly unfair form of discrimination when it's government doing it. Governments have enforcement officers, they have armies, they have the means of enforcing their will and their laws, and that's one of the reasons why it's so important. What about under statute? Consistent with Title VII of the Civil Rights Act of 1964, when is it permissible for an employer to treat an employee or a prospective employee differently on the basis of his or her race?
By statute, under Title VII, it is generally impermissible.
And permissible only in very narrow circumstances.
I believe so, and the statute itself has some restrictions in terms of to whom it applies,
right.
The employers.
Some exclusions in terms of religious employers, for example, not being able to discriminate on the basis of race, but it exempts religious employers within certain spheres in order to be able to protect that religious employer's discretion to operate within its faith and the rules of its faith. And by doing that, it makes that much clearer. By making that distinction, it makes that much clearer that discrimination on the basis of race in employment is not something that the law smiles upon, nor should it. Let's talk about the Commerce Clause for a minute, if that's all right. Now, at the time of the founding, the founding fathers didn't foresee, and almost certainly could not have foreseen, the invention of radios, televisions, airplanes, the internet, and telephone networks. And yet, all of those things are governed by federal law and not by state law. Why is this constitutional?
Well, Senator, the Commerce Clause was initially interpreted by the Supreme Court to be very broad, to allow for federal regulation of interstate commerce and the growth of the economy in this country. But over time, the Supreme Court has made clear that the Commerce Clause limits the federal government, that there is limited authority under the Commerce Clause. The state of the law now is such that the federal government, through the Commerce Clause, is only permitted to regulate channels of interstate commerce, instrumentalities of interstate commerce, and activities that substantially affect interstate commerce. And with respect to the third category, the Supreme Court has made clear in the Lopez case and in Morrison that non-economic activities are not covered by Commerce Clause authority. And in the NFIB case, the ACA case, the Supreme Court made clear that inactivity is also not covered and not authorized under the Commerce Clause.
Right. And most of the items that I identified in my question, in fact, all of them, I believe, would fall into the category of channels and instrumentalities of interstate commerce. We're dealing with interstate airways, airwaves, waterways, networks, things like that, things that depend for their existence, for their effectiveness on their operation interstate, such that they couldn't, no one could effectively regulate them and preserve their core function unless that was federal. Those fit into the category of the channels and instrumentalities. With the third item that you described, the substantial effects interstate commerce, is there much of a limiting principle there? I mean, you referred to Lopez and Morrison and NFIB versus Sebelius. To my knowledge, those are the only three cases the Supreme Court has decided since its ruling in 1937 on NLRB versus Jones and Laughlin Steel, which essentially created the modern substantial effects case, the modern substantial effects standard. Those are the only three instances in which the Supreme Court identified as outside the Commerce Clause authority something that Congress had enacted. Are these meaningful constraints in your view, or are they examples of Congress just getting reckless and sloppy in the way it drafted things? Some have argued, for instance, that as long as Congress doesn't get reckless and sloppy, it can do whatever it wants under those. Do you have any view on that?
Well, these cases come through the courts, so I'll be general. The fact that Congress is limited in its authority under the Commerce Clause is established law. It is a fundamental principle of our constitutional order. And those limits that the Supreme Court has recognized do carve out categories of activity that Congress is not permitted, the federal government is not permitted to regulate. Non-economic activity is a category. Inactivity is a category.
Now, the Supreme Court has also, through the Commerce Clause, established rules for things that the states may not do. This is referred to as the so-called dormant Commerce Clause. The dormant Commerce Clause acknowledges the power of Congress, the exclusive domain of Congress as being regulating interstate commerce. But there's no federal cause of action to allow for the invalidation of a state law under the Commerce Clause. It's been something that's been adopted by the courts. Is that an appropriate exercise of the court's judicial power, or does that amount to de facto legislation on the part of the courts?
Well, Senator, I wouldn't characterize it. I know that that's what the Supreme Court has permitted. The Dormant Commerce Clause is a principle that supports the interstate nature and regulation and authority of the federal government. And so states are not permitted under that doctrine to discriminate against other states, to preference their own commerce in a way that interferes with interstate commerce.
So I want to turn back for a moment to a line of inquiry you had with Senator Durbin earlier today when you were talking about your sentencing in these child pornography cases. I want to make sure that I understand your answer there. If I understand it, you were making the argument that your concern was that the laws in this area didn't adequately take into account the transfer of these materials by electronic means to be transmitted, received, and stored through computers. Am I understanding that correctly?
Well, Senator, the point that I was making was that the Sentencing Commission, back when I was part of it and even since, tasked with the responsibility to evaluate and make recommendations and look at the data and information about cases, has looked at the operation of the child pornography guideline. Not so much the statute, but the guidelines, which the Congress has tasked the Sentencing Commission with developing. And there are aspects of the child pornography guideline that Congress in legislation has required. They've required certain enhancements to be included in the guideline. And some of those enhancements, the data is now revealing, don't take into account the change in the way that that this horrible offense is now committed.
But the fact that it's easier to commit the offense shouldn't diminish the severity of the punishment, should it? I mean, any more than the more widespread availability of certain drugs, the more widespread availability of certain weapons might, I mean, you surely wouldn't argue for a lower sentence when certain things become easier in other criminal contexts. So why is this one different?
Well, the sentencing enhancements that are in the guidelines are designed to help courts differentiate between different levels of culpability. Congress will say this is an offense, whatever it is, and the maximum penalty is X. And in most cases, the range is between 0 and something like 20 years that Congress gives when it establishes a penalty. The point of the guidelines is to help judges figure out where in that range between 0 and 20 years a particular defendant should be sentenced. And the guidelines have gradations in them that relate to various aspects of the commission of the crime.
Go ahead.
Sorry. So the commission does data gathering and research to figure out how crimes are committed and what gradations should matter in terms of the range of culpability. Because the problem of not doing that or of getting it wrong is that you are not able to adequately assess and determine the differences among offenders on the scale.
I understand that. And so, but in these cases, as I understand it, all 10 of the cases that we've reviewed on record where you've sentenced someone for a child pornography conviction, in all 10 of those cases, you departed from the guidelines and departed downward. It's hard for me to understand departing from those in every case you've got, because isn't a departure supposed to be grounded in a finding that it's outside the heartland of cases in that range, cases of that sort?
Yes, Senator, and as I said before, these are horrible cases that involve terrible crimes, and the court is looking at all of the evidence consistent with Congress's factors for sentencing. The guidelines are one factor, but the court is told that you look at the guidelines, but you also look at the nature and circumstances of the offense, the history and characteristics of the offender. There are a series of factors. In the cases, you are also getting recommendations. And in most of the cases, I haven't pinned it all down, but in most of the cases, if not all of the cases, the government is asking for a sentence below the guidelines because this guideline system is not doing the work in this particular case.
Understood. Section 230 of the Communications Decency Act provides a degree of immunity for tech companies operating in the space of being online interactive service providers. It immunizes them from certain causes of action that would otherwise apply against them. Would it be within Congress's authority to condition the receipt and availability of Section 230 immunity on those online interactive service providers operating as a public forum that is not discriminating on the basis of viewpoint or the viewpoint of those posting on them? Would that be within our authority?
Senator, I can't comment on a particular issue about whether or not it is constitutional or not, but the criteria that you identify, it would be relevant, I think, as to whether or not the government is seeking to regulate along viewpoint lines under the First Amendment. That is something that is generally impermissible.
Thank you, Mr. Chairman.
Thank you very much, Senator Lee. Senator Klobuchar.
Thank you very much, Chairman and Senator Grassley. Welcome again, Judge, your wonderful family. They all seem to be awake throughout this entire hearing. I just wanted to, before I start, get at something Senator Lee was talking about. It's not the Dormant Commerce Clause, but I really appreciated early on how you talked about these child pornography cases. A former prosecutor could totally see where you were coming from when you talked about looking at these cases as a mom and a judge. And would it surprise you at all that other judges, including a number of them that were supported by our colleagues on the other side of the aisle, have given out similar sentences in child pornography cases?
No, Senator, it would not surprise me because these cases are horrific, and there's a lot of disparity because of the way the guidelines are operating in this particular area. But in every case that I handled involving these terrible crimes, I looked at the law and the facts. I made sure that the victims, the children's perspectives were represented, and I also imposed prison terms and significant supervision and other restrictions on these defendants.
Well, thank you. And I just also want to note, and I know others have brought this up, the letter of support from the Fraternal Order of Police, in which they said, from our analysis of Judge Jackson's record and some of her cases, we believe she has considered the facts and applied the law consistently and fairly on a range of issues. There is little doubt that she has the temperament, intellect, legal experience, and family background to have earned this appointment. We are reassured that should she be confirmed, she would approach her future cases with an open mind and treat issues related to law enforcement fairly and justly, and that matters a lot to many of us. Now, I want to go back to something I was talking about yesterday, and that is why today's hearing is so monumental, including that it is occurring at a time when we as Americans have been reminded again, due to the courage of Ukrainians thousands of miles away, that we can never take our democracy, or for that matter, our courts for granted. It is also happening at a time when we are seeing each other for the first time after a 2-year pandemic, connecting to each other again. And I hope this moment will be a moment where we see a renewed interest in our democracy, that we respect each other's rights and views, and that we see that we are not a nation of 300+ million silos. Instead, we are a nation committed to this idea that what unites us as Americans is much bigger than what divides us. And so in that context, you come before us with this incredible strength, legal acumen, grace under pressure that you have demonstrated today. And you also come before us, as we've noted, as the first Black woman to be nominated following 115 justices who have been confirmed. And I will note, of the 115 justices, 110 have been men. And I actually once reminded a late night show Trevor Noah of similar issues in the U.S. Senate. In fact, in the history of the U.S. Senate, of the nearly 2,000 people who have served, only 58 have been women. And he responded that if a nightclub had numbers that bad, they'd shut it down. But today, Judge, we're not shutting anything down, not the court, not the Senate, and you are opening things up. And I think one of the things your nomination presents is an opportunity to address a decline in the public's confidence in our court. Increasingly many, if you see public opinion polls, see the court as over-politicized or out of touch. At the same time, we've seen an alarming rise in threats targeting members of our judiciary for just doing their jobs. How do you think we can work to maintain the public's confidence in the court? What do you see your role in that?
Thank you, Senator. Public confidence in the court is crucial. As has been said here earlier, the court doesn't have anything else, that is the key to our legitimacy in our democratic system. And I am honored to accept the president's nomination, in part because I know it means so much to so many people. It means a lot to me. I am here standing on the shoulders of generations of Americans who never had anything close to this kind of opportunity. From my grandparents, who had just a grade school education, but instilled in my parents the importance of learning. And my parents, who I've mentioned here many times already, who were the first in their families to go to college. So this nomination, against that backdrop, is significant to a lot of people. And I hope that it will bring confidence. It will help inspire people to understand that our courts are like them, that our judges are like them, doing the work, being a part of our government. I think it's very important.
Very good. I think along those lines, your wonderful mentor, Justice Breyer, I quoted him about how he said, we can help maintain public acceptance of the court, and these are his words. We can do it best by helping ensure that the Constitution remains workable in a broad sense of the term. Specifically, the court can and should interpret the Constitution in a way that works for the people of the day. Like, as you know, it's, I think, Article 2, Section 2 doesn't refer to the Air Force because we didn't have an Air Force back then. So are there things about the Constitution that, of course, as we've gone along, have been interpreted to meet the moments of our time? What do you think Justice Breyer means when he says the Constitution should be interpreted in a way that works for the people of today? And do you think a justice can be both pragmatic and objective and respect history?
I do, and I think that the justices have demonstrated that. Some of their recent opinions have had to deal with modern technologies that did not exist at the time of the founding. So, for example, the Riley case, Carpenter case, these were Fourth Amendment decisions in which the court was asked to determine whether or not it violated the Fourth Amendment for the police to search someone's cell phone without a warrant, or for the police to use GPS location data to determine where someone had been without a warrant. And obviously, those technologies did not exist. But what the court did was it looked back at the time of the founding and determined what the reasonable expectations of privacy were related to the term unreasonable searches and seizures, which appears in the Constitution. And having assessed what that meant back then, they could use those principles to decide whether or not a cell phone is like someone's home these days, with all of the information and all of the things that are stored there. And the court determined that it was a violation of the Fourth Amendment, that the police officers needed a warrant, and they did so with reference to what the Constitution meant in history.
Very good. You were viewed as a judge, and you talked about this a bit yesterday, that writes lengthy opinions, that believes you should spell things out, and believes in being transparent. Is that a fair characterization? I don't wanna
That
put
is,
words in your mouth.
that is.
Okay, good. I'm sure your clerks know that. I want to talk to you about something, to me, that's a bit the opposite, and that's something that some have termed the shadow docket. And that includes decisions that the court makes on an expedited basis that are usually unsigned and issued without oral argument or full briefing. In the last few years, we've seen the court increasingly deciding cases in this way, often over the dissent of maybe 3 or 4 of the justices. Last term, the court granted 20 requests for emergency relief, a historically high number. 10 years ago, in the October term of 2011, the court granted only 6 requests in an entire year. When do you think it's appropriate for the Supreme Court to grant emergency relief, use this docket? When are the circumstances that warrant this? And I think you know these decisions have a profound effect on people's lives. I'll just use one example. Last fall, in a 1-paragraph decision, a majority of the court refused to stop the enforcement of a Texas law that severely restricts a woman's access to abortion. In that case, even Chief Justice Roberts objected to the court's decision to let the law take effect, calling the statutory scheme not only unusual but unprecedented. As someone who believes in transparency, could you talk in general about when you think this shadow docket should be used, when emergency relief should be given, and how, if it's overused, it could undermine public confidence in the court?
Thank you, Senator. Well, there's a balance that the court has to consider, and that it, insofar as, on the one hand, it has always had an emergency docket, the need for flexibility, the ability to get answers to the parties at issue is something that's important in our system. On the other hand, the court has also considered the interest in allowing issues to percolate, allowing other courts to rule on things before they come to the court. And I am not privy at the moment to the justices' views and why and how they're using the emergency docket in these cases. If I was fortunate enough to be confirmed, I would look at those issues, but it's an interesting and important set of issues.
Okay. You know, I think just another example of this, by the way, is the day before Wisconsin's primary election on April 6, 2020, right as the first beginnings of some of the health orders that came out with the beginning of the pandemic. The court issued a 5-4 decision halting a district court's order allowing voters extra time to cast their absentee ballots so that they could avoid waiting in line to vote. And back then, people literally got COVID with election workers and the like because of this. And again, I'm not going to belabor this point, but I think some of this is these decisions that are made that don't reflect some of the careful consideration that you have made in many of your decisions as a judge. But speaking of voting, I'll ask you one question on that front. Since the Supreme Court gutted the Section 5 preclearance regime of the Voting Rights Act in its decision in Shelby County, the D.C. Circuit has not seen many voting rights cases. However, as you know, Justice Ginsburg dissented in that case, describing the right to vote as the most fundamental right in our democratic system. Do you agree that the right to vote is fundamental?
Senator, the Supreme Court has said that the right to vote is the basis of our democracy, that it is the right upon which all other rights are essentially founded. Because in a democracy, there is one person, one vote, and there are constitutional amendments that relate directly to the right to vote. So it is a fundamental right in our democracy.
Yes, I know that's how Justice Barrett answered that question as well in her recent hearing. I'm going to turn to an area that Senator Lee and I, we both chair the subcommittee on antitrust, and so it's near and dear to my heart. So I thought I'd spend a little time. It usually gets relegated to the second round, but I'm putting it up on the docket here. U.S. antitrust law has been described as a comprehensive charter of economic liberty, and I agree. And effective antitrust enforcement plays a critical role, as you know, in protecting consumers and workers, promoting innovation, ensuring new businesses have an opportunity to compete. It actually, from really early on in our country's history, has been a very important part of assuring that capitalism works. And in January, for the first time since the dawn of the internet, the Senate passed a tech competition bill out of the Judiciary Committee. It's a bill that Senator Grassley and I lead. Many of the members of this committee supported the bill, 16-6 vote. It's called the American Innovation and Choice Online Act. It's now headed to the Senate floor. I'm not going to ask you about that bill, obviously, but I want to put this in some context. While tech monopolies have seized from 50 to 90% market share in major parts of their business lines, it is clear to me when you look at the plain language of the Sherman Act, Clayton Act, laws that are in place, that these monopolies are not okay. However, court rulings for decades in antitrust have created some major obstacles to taking on these cases. And it's not just court rulings. It is on us with, as I said, the dawn of the internet, decades having passed. It is on us, this Senate and the House, to update our laws this year to give enforcers the resources to do their jobs, something you, if confirmed, would not have a role in. But the role of the courts is also very critical. You have been nominated to replace Justice Breyer, who came to the court with a strong background in antitrust law. I know you handled a case. You and I discussed it in my office. I think it got decided the merger was abandoned, so you didn't have to rule on the merits of it. It was back in 2017, a FTC challenge. But I'll just quote something that Justice Breyer once said. He told this committee, if you're going to have a free enterprise economy, then you must have a strong and effective antitrust law. Do you agree with Justice Breyer's statement, and how would you characterize the goals of our antitrust laws.
Well, thank you, Senator. The antitrust laws protect competition and, as you said, therefore protect consumers and competitors and the economy as a whole. And the Sherman Act and the Clayton Act are broad in their in their statements and their protections, and there's a lot of precedent in this area. If I were confirmed, I would use my methodology to look at the precedents in these areas to ensure that any legislation that I was considering is interpreted according to the text, consistent with Congress's intent. And in the area of antitrust, that is ensuring that there is consumer protections.
Very good. And just to play it out a little bit, since the 1980s, the court in cases like Trinco and Credit Suisse, Ohio v. American Express, has really made it increasingly difficult to enforce the antitrust laws and protect competition. And during that same time, and I know many of my colleagues know this, we have seen a rise in industry consolidation, market power, not only in tech with companies like Google and Amazon and Facebook and Apple, but also across our economy, really in everything from pharma to cat food to caskets. What role do you think that congressional intent should play in the court's interpretation of the antitrust laws? And I say that because I think that we're dealing with some cases where justices have actually substituted their own ideologies for the intent of Congress in originally passing the laws. And I think it was Justice Souter who once said before this committee, when we are dealing with antitrust laws, we are dealing with one of the most spectacular examples of delegation to the judiciary that our legal system knows. And he added this, certainly a respect for legislative intent has got to be our anchor for interpretation. So what role do you think congressional intent should play in the court's interpretation of the antitrust laws?
Thank you, Senator. So I've interpreted a number of statutes in my near decade on the bench. And in every case, the text of a statute is what the court looks at in order to ascertain what the legislature intended. And that is important because, as I've said, courts are not policymakers, and judges should not be importing their own policy preferences. Judges are restrained in our constitutional scheme in order to affect the will of Congress in terms of their interpretation of the laws.
Okay, thank you. I'm going to turn to another topic, and that's freedom of the press, New York Times v. Sullivan, 1964 case. We have recently witnessed, as you know, unprecedented attacks on journalists and journalism, whether it's violence overseas, recently losing, sadly, members of the press just in the last month in Ukraine, or threats and intimidation at home. This is very concerning to me, given the important role of the First Amendment. My dad was a newspaper reporter, so the issues hit home for me. Can you talk about your view of the role of journalists in our democracy?
Thank you, Senator. Journalists, freedom of the press is protected by the First Amendment. It is about the dissemination of information, which is necessary for a democratic form of government. The Supreme Court has held as much, and that was the basis for the court's determinations in protecting the press from liability in New York Times versus Sullivan and its progeny.
Okay. As you know, that ruling was a unanimous ruling in support of the First Amendment, and the court held that when newspapers report on public officials, they're only liable for untrue statements that are published with knowledge or reckless disregard for whether the statement was false. The court in Sullivan based its decision on our country's, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That's their quote. And it recognized that, quote, erroneous statement is inevitable in free debate, end quote, must be protected if the freedoms of expression are to have the breathing space that they need to survive. Do you agree that those principles are just as relevant today as they were when the Supreme Court first decided New York Times v. Sullivan?
New York Times v. Sullivan is the continuing binding precedent of the Supreme Court, and it does state the principles that the court has determined are undergirding the First Amendment right to free press.
Okay. And last summer, actually, in Berisha v. Lawson, the Supreme Court declined to review a case in which the 11th Circuit applied New York Times v. Sullivan. Justice Thomas and Justice Gorsuch each dissented from the decision not to grant cert, arguing that the court should reconsider its holding in Sullivan. How would you approach a case that sought to limit or overturn the central holding in New York Times v. Sullivan?
Thank you, Senator. Anytime the court is asked to revisit a precedent, there are criteria that the court uses to decide whether or not to overrule a precedent. New York Times versus Sullivan is a precedent, and stare decisis is very important. The principle that the Supreme Court should maintain its precedents for predictability and stability in the law. If the court is asked to revisit a precedent, its criteria, what it looks at, are whether the precedent is wrong, and in fact egregiously wrong, the court has said, whether there's been reliance on that precedent, whether there are other cases that are similar to the precedent or that relied on the precedent that have now shifted so that the precedent is no longer on firm footing. Whether or not the precedent is workable. Sometimes the Supreme Court will issue a ruling and determine later that it's not actually doing what the court intended, and whether or not there are new facts or a new understanding of the facts. Those various criteria are what the court looks at to decide whether or not to overturn a precedent, and they would be what I would look at if I were confirmed to the Supreme Court.
Thank you. I was recalling as you spoke about stare decisis at one of your first nominations hearing for the district court, and you actually, in response to one of my questions, you said stare decisis is a bedrock legal principle that ensures consistency and impartiality of judgments. And I think, as you know, by how you've talked more broadly about this, moving off of the First Amendment questions, throughout the court's history, stare decisis has been so key, and the court has relied on it to maintain stability in the law, reaffirm its impartiality. As a former justice, I know Senator Durbin just read a very famous book about him, Minnesotan, Justice Harry Blackmun, who actually Justice Breyer succeeded on the court, said in his concurrence in Planned Parenthood v. Casey about the court's decision to uphold Roe v. Wade, he said, "What has happened today should serve as a model for future justices and a warning to all who have tried to turn this court into yet another political branch." What role do you think that stare decisis plays in protecting the independence of the judiciary and avoiding the perception that the court is acting as another, quote, political branch?
I think it plays a very important role as a doctrine that keeps keeps shifts from happening in the court. That as I previously mentioned, it's very important to have stability in the law for rule of law purposes, so that people can order themselves and predict their lives given what the Supreme Court has already said. And if there were massive shifts every time a new justice came on, or every time new circumstances arose, there would be a concern that public confidence would be eroded. And so stare decisis is a very important doctrine that the Supreme Court has established, and it's one that furthers the rule of law in this country.
Thank you very much. Well, that's a good way to end, Judge Jackson. And I do see Senator Cruz waiting in the wing. So by coincidence, and it looks like he has things he's putting up of charts. By coincidence, I was going to put on the record, and since he's here, it makes a lot of sense from the judge that you clerked for, Senator Cruz, Judge Ludwig, who's now retired, and I know you were very close to him. And he actually submitted a letter on your behalf, Judge Jackson, and said in this letter, and he's an appointee of George H.W. Bush, similar to Judge Griffith, who introduced you yesterday, and I've been very impressed by the support you've had from retired judges, obviously not appropriate for current judges, but retired judges appointed by both Democratic and Republican presidents, as well as the bipartisan votes that you have gotten through the U.S. Senate for your other positions. But in this letter, the former Judge Ludwig says that you are eminently qualified to serve on the Supreme Court of the United States. And then he actually says Republicans and Democrats alike should give their studied advice and then their consent to the president's nomination. And he adds Republicans in particular should vote to confirm Judge Jackson. So I thought that might be a good segue, Senator Cruz, to your question. So I asked Chairman that the letter of support from former Judge Ludwig, who employed Senator Cruz as a trusted law clerk, be admitted to the record.
Without objection.
Thank you very much, Judge Jackson.
Thank you.
Senator Klobuchar finds a Minnesota connection to almost everything. Very proud of the fact, but Justice Blackmun was born in Nashville, Illinois.
Okay, he was a lawyer at the Mayo Clinic, as we know, and spent a lot of time.
I'm going to lose this battle.
A lawyer in Minnesota when he was chosen to the Supreme Court, but thank you for pointing that out.
And now to the great state of Texas, Senator Cruz.
Thank you, Mr. Chairman. Judge Jackson, welcome.
Thank you.
Congratulations.
Thank you.
You and I have known each other a long time.
We have.
We went to law school together. We were on the law review together. We were a year apart.
Happily so, I hope, Senator.
We were not particularly close, but we were always friendly and cordial.
We were.
And you and I had a very positive and productive meeting in my office where we discussed a number of things, including you were there with former Senator Doug Jones. And we discussed how he and I and a number of other senators had, for 2 different years, participated in reading aloud on the Senate floor Dr. Martin Luther King Jr.'s letter from a Birmingham jail, which is one of the truly great advocacies for civil rights our nation has seen. And you and I talked together about our shared admiration for Dr. King. When Senator Grassley questioned you earlier, he asked in particular about Dr. King's speech on the steps of the Lincoln Memorial, where he said most critically, "I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character." Do you agree with what Dr. King said in that speech there?
I do, Senator.
As we were discussing it, you referenced in my office a speech that you gave in January of 2020 at the University of Michigan School of Law. And after our discussion, I pulled a copy of your speech and read the speech in its entirety. And there were elements of the speech that I thought were really powerful. And let me say, your opening remarks yesterday were powerful and inspirational as well. And I think you and your family, the journey you have taken to becoming a federal judge, to becoming a federal Court of Appeals judge, I think demonstrates the incredible promise and the incredible opportunity this nation offers all of us. As I read your speech at the University of Michigan Law School, however, there was a portion that surprised me. And in particular in that speech, you referenced the work of, quote, acclaimed investigative journalist Nicole Hannah-Jones, and her, and again, this is a quote from the speech, provocative thesis that America was born in, provocative thesis that the America that was born in 1776 was not the perfect union that it purported to be. And indeed, Ms. Hannah-Jones, in her 1619 projects, describes the central thesis of the 1619 project, which the New York Times laid out as a revisionist look of history, revising American history. And Ms. Hannah-Jones described her central thesis as, quote, one of the primary reasons the colonists decided to declare independence was because they wanted to protect the institution of slavery. Now, that claim is a highly contested historical claim. Do you agree with Ms. Hannah-Jones that one of the primary reasons the colonists decided to declare independence is because they wanted to protect the institution of slavery?
Thank you, Senator. When I gave that speech at the University of Michigan, I was asked to speak on Martin Luther King Day. And every year they have a Martin Luther King Day speaker. And I gave a speech about Black women in the civil rights movement. Most of the speech, if not all of the speech, was focused on African American women, their contributions to the civil rights movement, unsung contributions in many cases, and then some of the more recent African American women who have made claims, who have done things in our society. One slide was of Ms. A journalist, as you say, who made that statement, and I called it provocative. It is not something that I've studied. It doesn't come up in my work. I was mentioning it because it was, at least at that time, something that was talked about and well known to the students that I was speaking to at the law school.
So are you aware that since the 1619 project came out, that it has been roundly refuted by very respected historians, including Gordon Wood of Brown University, including James McPherson of Princeton University. McPherson called it a, quote, very unbalanced, one-sided account which lacks content and perspective. And indeed, it was so thoroughly refuted that the New York Times quietly altered the digital version to remove references to 1619 as the year of America's true founding and the moment America began. Were you aware of that?
I was not.
So let me ask you, related to the 1619 project, which I believe is deeply inaccurate and misleading. 1619 project is closely intertwined with a movement that is called critical race theory. Critical race theory, as you know, originated at your and my alma mater at the Harvard Law School. In your understanding, what does critical race theory mean? What is it?
Senator, my understanding is that critical race theory is, it is an academic theory that is about the ways in which race interacts with various institutions. It doesn't come up in my work as a judge. It's never something that I've studied or relied on, and it wouldn't be something that I would rely on if I was on the Supreme Court.
So critical race theory, as you know, has its origins in the critical legal studies movement, which also came from Harvard Law School, from a number of critical legal studies professors, crits as they were known when we were in law school, who are explicitly Marxists, and they find their origins in Marxism, although critical legal studies frames society as a fundamental battle between socioeconomic classes. Critical race theory frames all of society as a fundamental and intractable battle between the races. It views every conflict as a racial conflict. Do you think that's an accurate way of viewing society in the world we live in?
Senator, I don't think so, but I've never studied critical race theory and I've never used it. It doesn't come up in the work that I do as a judge.
So with respect, I find that a curious statement because you gave a speech in April of 2015 at the University of Chicago in which you described the job you do as a judge. And you said sentencing is just plain interesting because it melds together myriad types of law, criminal law, and of course constitutional law, critical race theory. So you described in a speech to a law school what you were doing as critical race theory. And so I guess I would ask, what did you mean by that when you gave that speech?
With respect, Senator, the quote that you are mentioning there was about sentencing policy. It was not about sentencing. I was talking about the policy determinations of bodies like the Sentencing Commission when they look at a laundry list of various academic subjects as they consider what the policy should be.
Okay, but
Critical
you were
race.
vice chair of the Sentencing Commission, so let me ask again, what did you mean by, because that was an official responsibility of yours, what did you mean by what you were doing was critical race?
What I meant was that there are a number of, that slide does not show the entire laundry list of different academic disciplines that I said relate to sentencing policy, but none of that relates to what I do as a judge.
So let me ask you a different question. Is critical race theory taught in schools? Is it taught kindergarten through 12th?
Senator, I don't know. I don't think so. I believe it's an academic theory that's at the law school level.
Okay. As you may recall, during the confirmation hearings of Justice Amy Coney Barrett, there was a great deal of attention paid to the fact that Justice Barrett served as a board member on the Board of Trustees of a religious private school, and the press focused very intensely on the views of that school. In your questionnaire to this committee, you disclosed that you are similarly on a board, specifically the Board of Trustees for the Georgetown Day School, and that you've been a board member since 2019 and you're currently still a board member. Is that correct?
That is correct.
In regard to the Georgetown Day School, you've publicly said, quote, "Since becoming a member of the GDS community 7 years ago, Patrick and I have witnessed the transformative power of a rigorous progressive education that is dedicated to fostering critical thinking, interdependence, and social justice." When you refer to social justice and the school's mission on social justice, what did you mean by that?
Thank you, Senator, for allowing me to address this issue. Georgetown Day School has a special history that I think is important to understand when you consider my service on that board. The school was founded in 1945 in Washington, D.C. at a time in which, by law, there was racial segregation in this community. Black students were not allowed in the public schools to go to school with white students. Georgetown Day School is a private school that was created when 3 white families, Jewish families, got together with 3 black families and said that despite the fact that the law requires us to separate, despite the fact that the law is set up to make sure that black children are not treated the same as everyone else, we are going to form a private school so that our children can go to school together. The idea of equality, justice, is at the core of the Georgetown Day School mission, and it's a private school such that every parent who joins the community does so willingly with an understanding that they are joining a community that is designed to make sure that every child is valued, every child is treated as having inherent worth, and none are discriminated against because of race.
So, Judge Jackson, all of us will agree that no one should be discriminated against because of race. When you just testified a minute ago that you didn't know if critical race theory was taught in K through 12, I will confess I find that statement a little hard to reconcile with the public record, because if you look at the Georgetown Day School's curriculum, it is filled and overflowing with critical race theory. That among the books that are either assigned or recommended, they include Critical Race Theory, an introduction. They include The End of Policing, an advocacy for abolishing police. They include How to Be an Anti-Racist by Ibram Kendi. They include literally stacks and stacks of books, and I'll tell you two of the ones that were most stunning. They include a book called Anti-Racist Baby by Ibram Kendi. And there are portions of this book that I find really quite remarkable. One portion of the book says babies are taught to be racist or anti-racist. There is no neutrality. Another portion of the book, they recommend to babies confess when being racist. Now, this is a book that is taught at Georgetown Day School to students in pre-K through second grade, so 4 through 7 years old. Do you agree with this book that is being taught with kids that babies are racist?
Senator, I do not believe that any child should be made to feel as though they are racist, or though they are not valued, or though they are less than, that they are victims, that they are oppressors. I don't believe in any of that. But what I will say is that when you asked me whether or not this was taught in schools, critical race theory, my understanding is that critical race theory as an academic theory is taught in law schools, and to the extent that you were asking the question, I understood you to be addressing public schools. Georgetown Day School, just like the religious school that Justice Barrett was on the board of, is a private school.
Okay, so you agree critical race theory is taught at Georgetown Day School?
I don't know, because the board is not, the board does not control the curriculum. The board does not focus on that. That's not what we do as board members, so I'm actually not sure.
Well, and I'll note that the board is chaired by Professor Fairfax, your college roommate who introduced you yesterday, so the two of you serve on the board together. Another book that is on the summer reading for 3rd through 5th grade is a book called Stamped for Kids, again by Ibram Kendi. I read the entirety of the book, and I will say it is an astonishing book. On page 33, it asks the question, can we send white people back to Europe? That's on 33. That's what's being given to 8 and 9 years old. It also, on page 115, says the idea that we should pretend not to see racism is connected to the idea that we should pretend not to see color. It's called color blindness. Skipping ahead, here's what's wrong with this. It's ridiculous. Skin color is something we all absolutely see. Skipping ahead, so to pretend not to see color is pretty convenient if you don't actually want to stamp out racism in the first place. Now, what this book argues for is the exact opposite of what Dr. King spoke about on the floor of the Lincoln Memorial. And are you comfortable with these ideas being taught to children as young as 4 in respect to the first book, as young as 8 and 9 in respect to the second book?
Senator, I have not reviewed any of those books, any of those ideas. They don't come up in my work as a judge, which I'm respectfully here to address. In my work as a judge, which is evidenced from my near decade on the bench,
Okay, good.
I am.
Then let's go back to your work as a judge. As was noted in the first slide, you discussed sentencing as being related to critical race theory. And earlier there's been some back and forth as Democratic senators have tried to address your sentencing patterns as it concerns child pornography. And I'll confess, Judge Jackson, as I listened to your testimony, I believe you are someone who is compassionate. I believe you care for children, obviously your children and other children. But I also see a record of activism and advocacy as it concerns sexual predators that stems back decades and that is concerning. You wrote your note on the Harvard Law Review on sex crimes. Your note is your major academic work on the Law Review, and yours is entitled Prevention versus Punishment Towards a Principled Distinction in the Restraint of Released Sex Offenders. And in it, you argue, and I quote, a recent spate of legislation purports to regulate released sex offenders by requiring them to register with local law enforcement officials, notify community members of their presence, undergo DNA testing, and submit to civil commitment for an indefinite term. Although many courts and commentators herald these laws as valid regulatory measures, others reject them as punitive enactments that violate the rights of individuals who have already been sanctioned for their crimes. Under existing doctrine, the constitutionality of sex offender statutes depends upon their characterization as essentially preventative rather than punitive. And what you go on to explain is if they're viewed as punitive, they are unconstitutional. If they're viewed as preventative, they are not. And throughout the course of your note, you argue they should be viewed as punitive and therefore unconstitutional. Indeed, in the second to last page, you go through each of those four categories. You say requirements that sex offenders register may or may not be unconstitutional, depending upon whether, quote, in which sex offenders have no privacy right in registration information or blood samples. So you suggest that may or may not be constitutional, although you raise doubts about it. And then you raise very significant doubts about community notification, and you heavily suggest that civil commitment for sexual predators is unconstitutional. Do you still agree with the sentiments you expressed in your law school note?
Respectfully, Senator, those are not the sentiments that I expressed in my law school note. My law school note was about sex offender registration laws, which at the time were relatively new. As you know from our time in law school, one of the things that law school students do is they look for new developments in the law and they try to analyze them. That's something that makes for good fodder for a law school note. My note, which came out in 1996, was shortly after there were new Megan's laws. And the point that I was making was not that the laws were bad, that the laws were wrong. I was trying to assess something that is sort of fundamental in terms of the characterization of the laws. I didn't say that they were unconstitutional one way or the other. What I was trying to assess was how they are characterized. Some courts would look at those laws and call them preventative, and that has a certain set of consequences. Some courts would call them punitive, and that has a certain set of consequences. And what I was trying to do is figure out how to make the determination whether they were punitive or preventative.
Well, your note argued that they were punitive, and I would note that view, there have been some on the bench that have advocated that. The Supreme Court in 1997 decided a case called Kansas versus Hendricks, in which it upheld Kansas's civil commitment statute. That was a 5-4 vote. This has been a question that has been close at the Supreme Court, and I would note beyond that, that in terms of the prevalence of these statutes, all 50 states and D.C. have registry requirements. 47 states have community notification requirements. All 50 states have DNA or blood banks for sex offenders requirements. And 20 of the states, the federal government in D.C., have laws that allow for the indefinite detention of sex offenders. I would note in the state of Texas, a state court of appeals, relying on very much the same sort of reasoning you advocated in your note, struck down Texas's sexually violent predator civil commitment law. At the time I was the Solicitor General of Texas, I personally argued that appeal in the Texas Supreme Court. And the Texas Supreme Court unanimously reversed the Court of Appeals and upheld our statute. And if the views you advocated in law school prevailed, civil commitment laws across the country would be struck down, releasing sexual predators. And under the argument, community notification and DNA bank laws could well be struck down as well. Is that an outcome that should concern people?
Senator, my note wasn't advocating for the striking down of those laws. My note was trying to identify criteria that I thought could be applied consistently to determine whether the laws were punitive or preventative.
But with respect
Either
to Jackson, you argued that they were punitive, and you further say in the note, if they're punitive, they're unconstitutional.
I was looking at 4 different kinds of laws, and not all of them, did I say, were punitive.
Okay, so let's take civil commitments laws. If you look at civil commitment laws right now, the UCLA School of Law, Williams Institute, estimates more than 6,300 sex offenders are currently detained in civil commitment programs. If the view you advocated prevailed, presumably those 6,300 sex offenders would be released to the public. Is that an outcome that should be concerning?
Senator, in law school, when I was writing a note, I was looking at a brand new set of laws that had not previously been enacted in any jurisdiction. They were new. And I was assessing at the time, as law school students do, what criteria I thought might be used by courts to make a determination in the future as to whether or not they should be treated as punitive and therefore not unconstitutional, but as therefore ones that carry with them certain rights versus preventative.
Judge Jackson, so you've pointed that these were views in law school, and listen, I will recognize that all of us, when we are students, may have views that as time and maturity passes on, we may change. But what troubles me is this was not just a law school view, it's one that has continued. So when you were vice chairman of the Sentencing Commission, you expressed significant concerns that the White House has argued that your quotes were taken out of context. So I want to provide the full context of your quote, because you said, yes, I want to ask you about the means by which we can distinguish more or less serious offenders. I know that all of you sort of touched on that. Mr. Futrell, you talked about going from singular to one-on-one to group experience. I'm just wondering if there's some sort of inevitable and natural progression from one stage to the other, such that you could say that the least serious offenders are in the singular experience stage. And I guess my thought is, in looking at some of the testimony that other people will have later in the day, I was surprised at some of the testimony with respect to the motivation of offenders, and we're talking about child pornography offenders, and that there are people who get involved with this kind of activity who may not be pedophiles and who may not be necessarily interested really in the child pornography, but have other motivations with respect to the use of technology and being in the group. And here are lots of reasons perhaps why people might engage in this. And so I'm wondering whether you could say that there could be a less serious child pornography offender who is engaging in the type of conduct in the group experience level because their motivation is the challenge or to use the technology. They're very sophisticated technologically, but they aren't necessarily that interested in the child pornography piece of it. Now I find that a pretty remarkable argument, that people in possession of child pornography are not actually interested in the child porn. They're not pedophiles. They're just interested in technology. Is that, and I wanted to provide the whole quote because the White House said that portions of this were used out of context, so this is your entire quote. Do you agree with that sentiment, that there is some meaningful population of people who have child pornography but are not, in fact, pedophiles or getting satisfaction from it?
Thank you, Senator, for allowing me to address what appears to be a question that I was asking in the context of a hearing on child pornography. You've provided the entire quote, and it looks as though I was asking that of someone, not taking that position. And the position that I've taken in all of my sentencings involving child pornography offenders is to ensure that despite the attitude and view of many of the offenders who came before me when I was a trial judge, that they were just lookers, that they weren't really harming anyone, that they were curating their collections and they never touched a child, I made sure that they understood that notwithstanding their collecting behavior, that they were causing significant harm.
So Judge Jackson, all right, you raise your actual sentencing, and I think that's very productive. Let's take a look at your actual sentencing. And you've had 10 different cases involving child pornography. These are the cases. There are two, U.S. versus Buttry and U.S. versus Can, for which the government did not make a recommendation. And you said earlier, when Chairman Durbin was trying to preempt this line of attack, you said it's a sickening and egregious crime, which I very much agree with. And you said the guidelines lead to extreme departures. Okay? Let's look at what the prosecutors are asking for. And I would note that this was in the District of Columbia, where prosecutors are far more liberal than many of the prosecutors in this country. And in every case in which, so United States versus Hess, there was a mandatory statutory minimum of 60 months, and you imposed 60 months because you had no discretion. In United States versus Nickerson, there was a mutual agreement of the parties to 120 months, and that's what you imposed. In every other case, United States versus Chazen, the prosecutor asked for 78 to 97 months. You imposed 28 months. 28 months is a 64% reduction. In United States versus Cooper, the prosecutor asked for 72 months. You imposed 60 months. That was a 17% reduction. In United States versus Downs, the prosecutor asked for 70 months. You imposed 60. That was a 14% reduction. In United States versus Hawkins, the prosecutor asked for 24 months. You imposed 3 months. That was an 88% reduction. In United States versus Savage, the prosecutor asked for 49 months. You imposed 37. That was a 24% reduction. In United States versus Stewart, the prosecutor asked for 97 months. You imposed 57. That was a 41% reduction. Every single case, 100% of them, when prosecutors came before you with child pornography cases, you sentenced the defenders to substantially below, not just the guidelines, which are way higher, but what the prosecutor asked for on average of these cases, 47.2% less. Now, you said you made sure the voice of the children was heard. Do you believe in a case like United States versus Hawkins, where the prosecutor asked for 24 months and you sentenced the offender to only 3 months? Do you believe the voice of the children is heard when 100% of the time you're sentencing those in possession of child pornography to far below what the prosecutor's asking for?
Yes, Senator, I do.
Could you explain how?
I will. A couple of observations. One is that your chart does not include all of the factors that Congress has told judges to consider, including the probation office's recommendation in these cases.
Well, Judge Jackson, we don't have those probation. The committee has not been given the probation office's recommendation. We would welcome them. Mr. Chairman, I would love to see those. We don't have access to them.
The second thing I would say is that I take these cases very seriously as a mother, as someone who, as a judge, has to review the actual evidence in these cases and based on Congress's requirement, take into account not only the sentencing guidelines, not only the recommendations of the parties, but also things like the stories of the victims. Also things like the nature and circumstances of the offense and the history and characteristics of the defendant. Congress is the body that tells sentencing judges what they're supposed to look at. And Congress has said that a judge is not playing a numbers game. The judge is looking at all of these different factors and making a determination in every case based on a number of different considerations. And in every case, I did my duty to hold the defendants accountable in light of the evidence and the information that was presented to me.
In 100% of the cases, was the evidence less than the prosecutors asked for?
Senator, the evidence in these cases are egregious. The evidence in these cases are among the worst that I have seen, and yet, as Congress directs, judges don't just calculate the guidelines and stop. Judges have to take into account the personal circumstances of the defendant because that's a requirement of Congress. Judges have to consider things like the victims, and when I was talking about making sure that victims' circumstances are heard, it was about my sentencing practices.
Well,
that I
show victims being heard with respect. Thank you, Mr. Chairman.
In 2012, the Sentencing Commission, on a unanimous bipartisan basis, issued a report recommending changes to sentencing for non-production child pornography, which is the subject at hand. Offenses because of widespread concern among judges and other stakeholders. For example, 70% of surveyed judges said the guideline ranges for possession and receipt offenses were too high. 71% said the mandatory minimums were too high. Notably, the report was supported by every member of the commission. I believe the question which Senator from Texas was referring to was part of the proceedings that led to that commission report, unanimous convention, bipartisan basis commission report.
Mr. Chairman, very briefly, I would ask unanimous consent that the books I referenced be entered into the record.
Without objection. Senator Coons?
Thank you, Chairman Durbin, Ranking Member Grassley. Judge Jackson. Good to be with you.
Good to be with you, Senator.
I'd like to take a few minutes, if I could, and just give you a chance to address some of the issues just raised. My colleague suggested that you've never sentenced a defendant in a child pornography case consistent with what the government requested, what the prosecution requested. But according to my staff's research, that's just not true. So let me briefly ask you about three specific sentencing cases. Do you remember U.S. v. Nickerson? You sentenced Charles Nickerson Jr. to 10 years in prison. Exactly what the government requested.
I do, Senator.
Do you remember U.S. v. Fife? You sentenced him to 20 years in prison. Exactly what the government requested.
I do, Senator.
And do you recall U.S. v. Nguyen? You sentenced him to 37 months in prison. Exactly what the prosecution requested.
I do, Senator.
So in these three cases, it's also true that the government, the prosecution, requested below guidelines sentences. Would that seem surprising to you at all?
It would not.
And is that because overwhelmingly, nationwide, in 70% of cases, and in your district, 80% of cases, downward departures from the guidelines are the norm?
That is correct, Senator.
So to the extent there seems to be some concerted effort to try and characterize you as being soft on crime or somehow unconcerned about child safety, I just wanted to take another moment and give you a chance to respond to that. As a parent, as the member of a family that's had several members who've served your brother, your uncles in law enforcement, Could you share a bit about how having loved ones who serve as law enforcement officers, in one case a detective on a sex crimes unit, has had an impact on your sense of the balance of justice and mercy in the case of ensuring that we hold to account those who commit crimes against children?
Thank you, Senator. As a mother, these cases involving crimes against children are harrowing. What I think is important to understand is that trial judges who have to deal with these cases are presented with the evidence or descriptions, graphic descriptions. These are the cases that wake you up at night because you're seeing the worst of humanity. When there are victim statements that are presented, when people talk about how their lives have been destroyed as children, how the people who they trusted to take care of them were abusing them in this way, and then putting the pictures on the internet for everyone to see. I sometimes still have nightmares about the main witness, the woman I mentioned earlier, who cannot leave her house because of this kind of fear, the vulnerability, the isolation. These crimes are horrible. And so I take them very seriously, just as I did all of the crimes, but especially crimes against children.
So, Your Honor, if I could, the characterization that was just presented in a recent column in the National Review, a conservative publication, has characterized that view of you as a smear that appears meritless to the point of demagoguery and characterizes your approach in sentencing in these cases as mainstream and correct. And I'll just remind my colleagues and those watching that two of the largest, most substantial law enforcement advocacy organizations in our country, the National Fraternal Order of Police and the International Association of Chiefs of Police, have spoken up in support of your qualifications and your capabilities. The FOP letter says there's little doubt you have the temperament, intellect, legal experience, and family background to have earned this appointment. That sentiment was echoed by the IACP. In their letter, they said, you believe you have a deep understanding of and appreciation for the challenges and complexities confronting the policing profession, and you have, during your time as a judge, displayed your dedication to ensuring our communities are safe and that the interests of justice are served. I find it hard to believe that these organizations, having looked closely at your judicial decisional record, your sentencing decisions, your lifetime conduct, would have taken those unusual steps to be that forceful in supporting you if, in fact, you had somehow a disturbing record of coddling child pornographers or being soft on crime. In fact, Judge, your record, in my view, demonstrates you're an even-handed and impartial judge. And I can see that when I look at cases you've ruled on that involve very politically charged or partisan interests. You've delivered rulings on both sides for plaintiffs and defendants, and in my review of your record, you've put any personal views or concerns aside. You've based your decisions on the argument of the parties, the facts in the record, the applicable law and precedent, and the well-reasoned and thorough opinions you've written show to me a judge striving to make even-handed decisions based on facts and law, not on some caricature of a leftist agenda. But don't just take my word for it. We've received an outpouring of support for your nomination. As we'll hear on Thursday, a very wide range of groups and individuals have sent letters or testimony to this committee in support of your nomination. It's no surprise to me that your legal mind, your experience, your temperament inspire strong support from some of the best and brightest of our legal community. And I think it's worth highlighting that among those many who have written to us are included well-respected conservative and Republican lawyers and Republican-appointed judges who agree with my characterization that you're an even-handed and impartial judge. We've received a letter from 24 conservative lawyers who held positions in Republican administrations or are well known for their conservative political or legal views, who wrote this committee to urge your speedy confirmation. They praised your character and intellect and called you, and I quote, a truly excellent person. I'd like to focus, though, on the way that these conservative lawyers characterized your judicial decision-making, which is, after all, the core issue before us, is whether you are the sort of judge at the district court, circuit court, that should be elevated to the Supreme Court. And they note in this letter that in nearly 10 years on the bench, as a district judge and then in the Court of Appeals, Judge Jackson has been involved in thousands of cases, running the full range of federal law. You're approximately 500, I think it's more than 570 now. Opinions written during this time have, and I'm quoting, demonstrated complete command of the legal subject matter, a judicious and even-handed approach, a fine ability to express yourself with force and great clarity. They've also demonstrated, and I'm quoting, another attribute essential for a judge, a sense of empathy for the situations of others. Judicious and even-handed. These prominent conservative lawyers want this committee to know you're judicious and even-handed and recommend you for the Supreme Court without reservation, despite having noted they differ with you concerning some political or partisan issues. And they're not alone. Judge Griffith, in a letter to this committee, and then followed up with personal testimony in your introduction yesterday, a judge appointed by former President George W. Bush enthusiastically supports your nomination. I was struck by his description of your intellectual capacity, your keen legal mind, as well as your character and judicial approach. And now I'm quoting from his testimony to this committee yesterday. Judge Jackson, he told us, is an independent jurist who adjudicates based on the facts and the law, not as a partisan. He went on, as Justice Scalia taught us, an indispensable feature of the republic the Constitution created is an independent judiciary of judges who've taken an oath not to a president or a party, but to the American people and to God, that they will be impartial. And he concluded that you, Judge Jackson, have demonstrated an unwavering commitment to that oath. That's a conservative judge appointed by a Republican president who told this committee he's confident you'll decide cases based on the facts and the law, not as a partisan. Now, I value the working relationships I have with my colleagues on both sides of the aisle. We can and do at times have fierce policy disagreements, but we also work together to try and find ways as lawmakers and individuals to respect each other. And I take it as a personal sort of badge or a source of pride when someone with whom I really disagree on one issue is able to legislate with me on another. And so I imagine, Your Honor, it must be gratifying to know that a judge who literally sat in judgment of, reviewed dozens and dozens of your opinions. In fact, I think he reversed you once.
Oh, more than. More than.
Here is someone who closely read and reviewed your decisions, and as a circuit judge sat in review of your work over years as a district, hundreds of opinions as a district court judge, and has such unequivocal praise for the even-handed, impartial, thorough, and nonpartisan way you've approached judicial decision-making. Could you just briefly share with me what it means to you to hear that someone like Judge Griffith has such confidence you would make an excellent member of our highest court?
Thank you, Senator. It means the world to me to have the support of Judge Griffith. His coming here yesterday and testifying on my behalf was so gratifying. I have tried in every respect to follow my methodology that enables me to rule impartially in every case and to understand the limits of my own judicial authority and thereby reach decisions without fear or favor. My record demonstrates that I am not proceeding from any sort of preconceived notion about how a case comes out. I'm not ruling consistent with any sort of ideology. I'm doing what impartial and fair judges do, which is to decide in every case based only on the facts and the law of that case. And I'm very, very pleased that Judge Griffith has seen that in the years that he supervised me effectively as a Court of Appeals judge when I was a district judge. And I think it's wonderful that he was able to come here and testify to that.
Well, Judge, for those watching and for those following this, that they might be puzzled because my colleague, the junior senator from the state of Texas, has tried to ascribe all sorts of views to you in his recent questioning that try to paint you as some kind of an activist with a radical agenda. And in my review of your experience and your record, these letters from judges and scholars, I don't see anything that remotely substantiates that claim. We are here to evaluate your qualifications, your judicial decision-making. But so let me get at a few of these points specifically, if I could. I've heard references to the 1619 Project and critical race theory, but I didn't hear that cited in any reference to your opinions as a judge. In your 9 years on the bench as a district court judge, more than 570 decisions, have you ever cited the 1619 Project?
No, Senator.
In your 9 years on the bench and more than 570 opinions, have you ever cited the journalist or principal author of that 1619 Project, Ms. Hannah Jones?
I have not.
And in your 9 years on the bench and more than 570 decisions, have you ever used, employed, relied upon critical race theory to determine the outcome of any case or to impose any sentence or as a framework for your decision-making?
No, Senator.
Would you just explain to us briefly what sort of factors you do, in fact, consider in your analysis?
Senator, when I analyze a case, I am looking at the arguments that the parties raise in the case. I'm looking at the record, which is the facts of the case developed, if I'm on the Court of Appeals, developed below. And I'm looking at the law. I'm looking at any statutes. I'm hewing to the text. I'm looking at constitutional provisions to the extent that they are applicable, and any precedents related to the case at issue. Those are the inputs that are appropriate for a judge to consider, and those are the only things that I use in my decision-making.
Well, I appreciate your laying that out, and I'll just, let me dig into two cases, if I can, that I think are also probative here, because I agree with the wide range of supporters we've heard from that you've demonstrated an even and impartial judicial approach in your record. But this is true not just in the hundreds of sort of run-of-the-mill quotidian cases that are considered by a district court judge, but in several that have been highly charged and really quite political in terms of their consequences. I'd like to discuss your opinion in the Center for Biological Diversity versus McAleenan. Do you recall that case?
I do, Senator.
It was a dispute between groups advocating for environmental protection and the Trump administration's Department of Homeland Security. The dispute was about President Trump's efforts to quickly construct a physical border wall between the United States and Mexico. I'm sure I don't need to remind you or anyone here that at the time, Democrats were just about unanimous in thinking that physically building a wall from coast to coast was not the wisest use of resources to secure the border. There were other ways to do it, and with Republicans pretty much unanimously willing to defend it. So it was a policy matter with some sharp divisions and some political consequences. You ultimately ruled in favor of the construction of the wall and against an attempt by environmental groups to halt its construction through a legal case. Can you discuss what you recall just briefly of the claims presented and how you came to a decision in favor of the Trump administration?
Senator, the claims in that case, which, as you say, were brought by an environmental organization, related to the Administrative Procedures Act, which is something that we often see in the District of Columbia, and whether or not the agency could waive certain environmental laws pertaining to the construction of the wall, whether or not the agency's determination to do so was lawful. And I looked at the relevant circumstances, and I ended up, I believe, dismissing that case on threshold grounds before getting to that point in the analysis. But consistent with what you said, I was guided by my understanding of the law and what it required, and not by anything else.
I could spend a lot of time on the details of this case, but let me try and summarize it this way. You analyzed the statute. You concluded Congress had clearly blocked the courts from hearing non-constitutional challenges. There was no jurisdictional bar to the constitutional claims. To decide them, you considered whether the plaintiff's claims were viable. You looked for precedent. You found one. While not controlling, you thought it was legally sound and persuasive. But there was no controlling circuit court or Supreme Court precedent that stopped you. If you were in fact an activist judge, a motivated partisan determined to let these plaintiff environmental groups proceed, you certainly could have. There was no clear precedent that barred that from happening. You analyzed the statute. You applied the best precedent you could find, and you reached a result without regard to the political consequences.
That is correct, Senator.
So in my view, I wanted to talk about this case because there's really nothing unusual or special about it from your perspective.
That is correct.
For those of us up here, there was a lot special and important about it. It was a highly charged partisan and political issue, but you looked at the statute, you found persuasive precedent, you applied it, you went on to the next case. Well, let me ask about another decision. In a case addressing another very politically charged issue, and specifically this involves the emails of former Secretary of State Hillary Clinton. Now, the Republican National Committee, or the RNC, is opposing your nomination, publicly accusing you of being a partisan Democrat. And they argue you could not possibly be an impartial justice. But ironically, back in 2016, you presided over a case brought by the RNC against USAID related to then presidential candidate Clinton, and you ruled in favor of the RNC. Both the substance and the timing of the case are really quite striking.
I did.
The RNC made Freedom of Information Act requests for certain emails involving the former secretary, and despite what the RNC would have us now believe, in this case, you reinforced your deserved reputation for following the law, not a partisan agenda, because you ordered USAID to produce thousands of pages of documents related to Secretary Clinton. Do you recall when you issued that decision, that order?
I actually don't.
Well, I'll tell you, it was just before the presidential conventions. So if there was a moment when the RNC had a political objective, it was right before the convention, and you actually issued a ruling that they were entitled to email production from the USAID on the basis of legal arguments presented to you, the statute at issue, and the evidence. Is that correct?
That is correct.
Well, Your Honor, I'm frankly really struck at the fact that, for all the back and forth in Senate hearings and academic circles about the judicial philosophy of Supreme Court nominees, you've shown what the experience of nearly a decade overwhelmingly spent on the district court has produced. A methodology, an approach that looks at the Constitution, the statute, the facts, the arguments of the parties, and reaches a result without fear or favor, without taking into account the partisan issue at stake. I don't believe that a judicial philosophy is always all that meaningful. The judge for whom I clerked on the Third Circuit had spent years as a district court judge, and when I asked her, what's your judicial philosophy, she looked at me and said, I just call balls and strikes. I'm a judge who rules on the case before me in exactly the same frame that you offered. A judicial philosophy does not in and of itself constrain a judge. What constrains a judge is a judge who is willing to be constrained, who understands that the role of the federal judiciary is a limited one. And so the real question I think a president should consider when they make a nomination the question that we as senators need the answer to in order to perform our function of advice and consent, and the question that I think resonates best with the American people, who are concerned about this hearing and this nomination and how it will impact the country and their lives, is sort of, what kind of justice will you be? We want to know if you'll be fair. We want to know if you'll be faithful to the Constitution and to the rule of law. You've been a judge almost 10 years, and you've written more than 570 opinions. I'd say your record as a judge is the best answer to the question, what kind of justice you will be. How would you say, Your Honor, that your approach to judging on the district court relates to the way you are now judging on the circuit court? And what approach do you think you will bring with you if confirmed to the Supreme Court?
Thank you, Senator. My approach all the way through is one that I believe is required by my duties, by my oath as a judge. We rule without fear or favor. We are independent as judges in our responsibilities. We understand at the district court level, at the Court of Appeals level, and at the Supreme Court that judges are restrained, are constrained in the exercise of our power under our constitutional scheme. My methodology is designed to help me to make decisions within those confines at every level. It's no different now that I'm on the Court of Appeals than when I was on the district court with respect to my understanding of the constraints on my authority and my responsibility to be impartial in my rulings. And I think it would be no different at the Supreme Court.
Well, Your Honor, I know we've walked through just a few cases today now. In some ways, we've only scratched the surface of your decade and the more than 570 opinions you've written. But it's clear to me from what I've reviewed and from just this sample that, as we also heard from colleagues, from conservative lawyers, from judges who wrote to the committee, that you are judicious and even-handed, that you have a demonstrated record of excellence, that you adjudicate based on the facts and the law and not as an advocate, activist, or partisan. And I encourage my colleagues who want to know what kind of a justice you'll be to take a fair and even-handed look at your record, at your impartiality, and at your methodology. Your experience is extensive and broad. Your commitment to follow the law impartially and without the influence of politics is evident in your record. Your keen legal mind, judicial temperament, and impeccable character are plain to all. As Judge Griffith told this committee in a review of your record makes clear, you've demonstrated that the way you approach cases is based on the law and not on some political agenda. You understand the reason why the robes of our federal judges are black, not red or blue. The American justice system, as many have said, is rooted in the impartiality, the independence, and the reliability of our federal judicial system. It is one of the most critical bulwarks of our system of ordered liberty. No wonder that when you came before this body to be confirmed for the district court, then the circuit court, you earned and received bipartisan support. I know President Biden counts nominating a Supreme Court justice among the most significant decisions of his presidency, and our role here in the Senate in confirming a justice to our highest court is among our most solemn obligations and greatest privileges. So in nominating you, I believe our president has met his mission, and it will be my honor to join, I hope, the overwhelming majority of my colleagues in supporting your confirmation as an Associate Justice of the United States Supreme Court. Thank you, Your Honor.
Thank you, Senator Coons. Last week, the committee received a letter, Judge, from the National Coalition Against Domestic Violence, representing survivors of domestic violence, urging the Senate to swiftly confirm you to the Supreme Court. The committee also received a letter about your nomination from 9 separate organizations representing both survivors of domestic violence and sexual assault. The letter said, and I quote, Judge Jackson is highly qualified for the position as her career and record demonstrate. Her historic confirmation as Supreme Court's first black woman and the 6th woman overall will represent monumental progress toward a nation It is charged to serve, and that values all of its citizens equally. The organizations also noted, quote, Judge Jackson's rulings reflect the judicial consensus. I move to enter these letters into the record. Without objection, they will be. Senator Sass, you're next up, but we're on the cusp of a vote. So I want to be fair to you. We're going to take a break at this point. I'm going to hope.
I thought we were taking a break and gonna go vote, but if you want me to go first, I'm good.
No, I think we ought to go over there and
Okay.
pray that it comes along and we can return quickly. So why don't we declare this break time for 20 minutes, 4:05, back in the room.